Welcome to Rebel Chaser. My name is Gail, and I've got two videos for you today. They're both wacky rental ones. The first one is with Judge Shepard in Texas, and then the second one is with Judge Middleton in Michigan. I'll let you guys watch.
Okay, this is Judge Eric Shepard presiding in Travis County Court at Law Number 2, and I'm calling this hearing to order in cause number C1CV2500245, Brandy Milligan versus Clement Runnels. If you would announce yourself for the record, tell me who you represent and whether you're moving or responding in today's hearing.
Brandy Milligan, represent myself.
All right. Mr. Runnels, are you there? Mr. Runnels, are you there?
Yes, this is Clement Runnels, and I'm here representing myself, sir.
Okay. I'm going to ask both of you to raise your right hands. Solemnly swear that you tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yes, I do.
All right. Ms. Go right ahead. Yes,
I'm
ma'am.
sorry. Are you
May I
talking?
speak?
Well, just a second, sir. Ms. Milligan,
Okay.
what is it that you want to do today? You're the movant, so.
Yes, sir. So I'm here today to get Mr. Runnels out of the apartment that we shared. I was told by the apartment complex that I needed to continue with this because I got out of the lease in April, and they contacted me 3 months later, telling me that the courts told them that I had to finish the process since I started it.
So the apartment complex told you that you had to finish are you living in the apartment complex now?
No,
Is your
sir.
name still on the lease?
No, sir.
Then your name is not on the lease and you're not living in the apartment complex.
No.
And you're here today because the apartment complex has told you that you have to finish the process because you started this process.
Yes, sir.
All right. But your name, I'm sorry to repeat this, but I'm just trying to get it straight. Your name is not on the lease of that part of that it was before.
So I don't understand it either. So again, like I got this apartment in October of 2024, and me and Mr. Runnels was involved for a very short time. I had asked Mr. Runnels to leave upon, things not working out amongst us. Um, he had became physically and verbally abusive. So basically, I went to the courts and so like I left February 1st, was told by
You left the apartment complex on February 1st,
yes, sir. So
and did you get a protective order?
yes, sir.
And who procured the protective order for you?
What do you mean who procured it? What?
How did you get the protective order?
So I went to the Travis County, I guess like downtown, and got that from them, and I got that was approved April 2nd. Um, and so basically, I also went to an advocate center. They're the ones that typed up the letter to allow me to get out of my lease. In April was when I got April 14th was when I got, out of the lease per the documents that I had. And
You have a copy somewhere of the letter that they
yeah,
used?
yeah, I submitted all of that to the courts, but I do
You
have
submitted it to whom, the court below?
no, I submitted it to you guys. I went in and gave the documents and they scanned them in.
Oh, so it's in the Justice of the Peace Court file.
Yes, sir.
All right, so this is what I'm going to do. I'm going to take judicial notice of all documents and exhibits in the court file of the Justice of the Peace, and all of those documents are admitted into this case. All right, so go right ahead.
Yes. Okay, yes, sir. So yes, I provided a copy of the lease to the judicial system. I provided that letter. Um, I provided the protective order. I provided my last light bill. I provided all documentation showing where I was the only person paying rent from October all the way up until April when I was released out of the
How
lease.
did you show that you were the only person paying rent during that time?
I'm sorry.
How did you show that you were the only person paying rent?
It's a portal that we have, and so I printed that screen out and I submitted that. And then I also submitted that same portal where the rent is currently almost at 7K, where Mr. Reynolds has not been paying.
Okay, so
Um,
just for the record, everything that you just mentioned, the portal entry, the lease, and all the other documents that you stated here are now admitted into evidence in this case.
yes, sir.
Okay, go ahead.
Yes, sir. And so basically, uh, and let's see. So basically, April 15th, I turned the electricity out. And also the apartment turned the electricity out. And Mr. Reynolds, I guess, took a piece of mail per the apartment, got the electricity turned back on in his name. And so that's how he's showing evident of him paying the light bill, which again, lights rent was never paid by Mr. Reynolds. Mr. Reynolds was never on the lease. Currently is not on the lease. He was not on the lease due to him not providing his documentation to the office, which the office was aware of that, and would ask Mr. Reynolds when they would see us, was he going to come in and, do the documentation, and he would always come with an excuse and never would get the documentation to the apartment. What he basically argues is the apartment kept telling him that they were going to put him on the lease, which they were per him given receipt of documentation that was needed so they could run his background and put him on the lease.
Okay. And so what are you asking the court to do today?
So today I'm asking the court to remove Mr. Reynolds from the unit so the apartment complex can get the unit back on the market and start getting a renter in there to pay, the rent.
What and is there any particular person you talked to at the unit?
Yes, so I was talking to the manager. Her name is Ashley Lopez.
Ashley?
Yes, sir. Lopez. She's the manager there.
He is?
He.
Okay, and so and do you have a number for her?
Yes, sir. Let me am I able to go
That's
out of
it would be the number of the apartment complex, right? Or is
yes, it's the number of the apartment complex, sir. Yes, sir. One sec. Let's
Yeah, I
see.
don't need her. If you have a cell phone, I don't want her cell phone number.
No, sir. It's the number of the apartment complex. And then they also April 27th, because how I get into the apartment was through my phone, and Mr. Reynolds had the fob. So on April 27th, Miss Lopez contacted me stating that she had disabled the fob and had maintenance go to lock the door to try to get Mr. Reynolds to leave the premises. Upon Mr. Reynolds returning, he kicked the door in. And so I guess police was notified on that particular day. And they were basically told that it was nothing that they could do because Mr. Runnels had his belongings there. And at that time, I was coming up for the hearing, which was on March 10th, which, like I said, that was February 27th that he kicked the door in. And I have the number here, sir, if you're ready.
Yes, ma'am.
737-358.
And the lady, that's Ashley's number?
Yes, sir. That's the office number. So
Office number.
yes, sir. So when you contact the office, one of the uh leasing agents will answer, maybe her. I'm not sure who would answer.
Okay. All right. Anything else?
No, sir. I think I've expressed everything. Like I say, I'm here today to get him removed out of the premises because, like I say, here I am thinking that he was already gone because I had contacted courts in April.
Who told you that you had to finish the process? Who was it?
April, Ashley Lopez.
Ashley Lopez did?
Yes, sir.
And when did she do that?
She contacted me. One second. She contacted me July 3rd.
Okay.
I'm sorry. That's not her. It's her number at June. Hold on, because I got to get that last email she sent. Yeah, she had like all the dates that the court gave her and everything, and was like, they told me that you had to finish the process since you started it. And she said court also told her that she couldn't be present because it was, basically my I guess hearing or whatever. Um
What hearing was, what court was this?
your court. So basically she contacted you guys court.
County Court at Law number 2?
Yeah, well, not necessarily law number 2. It's a number that we were provided, which she gave me that number. One second, which I think is connected to you guys. Hold on.
Yeah, but I'm asking, when you went to the Justice of the Peace Court, whose Justice of the Peace Court was it?
Oh, you're talking about in the beginning?
Yes, ma'am.
Precinct 1.
Okay.
And she contacted me with this information. Um, it was July. It was June 26th.
Is that when she told you you had to finish the process?
Yes, sir. That's when she contacted me. She had all of the court dates that court gave her, which they gave me those same dates, which was July 30th, August 12th, August 13th. And that is the same day that she informed me that when she contacted the court, they informed her that I was the one that started the process, so I needed to finish it.
And that's okay. And that was the Precinct 1 court that was saying that, correct?
No, that was like I say, it wasn't necessarily court 2 because we weren't given a court date yet. That was where's that number at? Because I called this same number and spoke to someone by the name of Celine, and once I explained to her like that I was off the lease and had a protective order, she informed me that she didn't see any reason why I needed to continue to do a court case, because I contacted the court on April 3rd, and that's when I informed Celine of everything that was going on. And she was basically saying for me to talk to the protective order attorney because she didn't see any reason that I should have to follow through, with this. And basically the apartment should be picking up, the case or whatever. And then, like I say, 3 months later, here comes the office calling me, asking me what happened with court. And I'm like, I never went to court because I was told that I shouldn't have to go. But the number, sir, that we were calling was 512 854-9242. And that's the number that she basically gave me. And that's the one that we was calling.
Okay. All right. Anything else?
That would be all, sir.
All right. Thank you.
Thank you.
Okay. May I start, sir? Your Honor?
Yes.
Yes. Well, I want to start from the very beginning. I met Brandy on the internet, and we talked and we met.
Mr. Clemens, I don't need to know
Yes,
about that or how the relationship got started.
Well, I understand that. I was just getting to the point of how I did end up on a lease and how I ended up from Houston to, that's why I feel that's very necessary, because I do have a counterclaim that is also been submitted. So all this is based off of that. So that's why I need the testimony to be on record.
Today, Mr. Clements, all we're here is to figure out who has a greater right of possession to the apartment complex. This isn't about the counterclaim.
Well, I know. I just, like I said, I wanted to be able to state these things because all this will be called up in the courts. So
no, sir,
the
I
case,
don't believe it. No, sir, hold on. This hearing today is about who's on the lease, who's responsible for paying the lease, and who has basically it's who has the greater right of possession. It's not about your counterclaim. It's not about what you think needs to be paid. It's about, did someone pay it's about the lease. It's about who's supposed to be there and who's not, and who's responsible for getting on and off the lease. This is about who has a greater right of possession. It's not about any of the other things you did.
Right. And believe me, I am aware of that. I'm aware of all the property laws, and these things have been told by my lawyer and all the assessments I've done under this case. I have the case numbers and all that validates my claims of her not having occupancy and no rights to property. But I wanted to go over it. I guess I could just skip part of that because all of that will be on a later date. The point of fact is I moved here and we got an apartment together. We searched for the apartment, went to the apartment together. Guy who was there, who I found out that she knew and she was talking to, as well as that assistant manager who keeps calling her, told me personally that it would be good for me to not be on the lease from the filing to make sure it goes through, and they were going to add me because I did have a background and I had things that I probably made where I shouldn't be able to get the apartment.
So it's correct that you were not on the lease?
Yes, it was correct that I was to be put on the lease. That's the point. I filled out all the paperwork there at the president, and they helped my paperwork, and they said once she goes through that I will be added to the lease. So I did fill out the paperwork. It was them who did add me and then took me off or whatever.
Mr. Clements, when you say it's them, who are you referring to?
I'm speaking of the assistant manager, Ashley, and another guy named
So you're talking about
So
you are speaking about the people who work for the apartment complex. And this is what
yes, sir.
You should say, I need you to identify who specifically is telling you these things, because them is not something I can figure out what happened. So if you want to say Ashley or you want to say somebody's name, that's fine. If you want to say the apartment complex people, that's fine. But if you say if you say them or him or her, I don't know who that is.
Yes, sir.
Okay.
Yes, well, Ashley, and a past employee who were also fired due to inappropriate dealings with Brandy Milligan. That has been stated that they have had conversations that are not needed to that were not based around
Clements, I want to focus, Mr. Clements. We need to focus on who is on the lease, who's not on the lease, who has a greater right of possession, and what the court can do with the lease and this apartment complex.
Well, I am supposed to be on the lease and should have been on the lease. I went through all the proper process, and if it was due to their negligence or something illegal, because I was there from the very beginning of the whole process.
I understand that you believe that they didn't do the right thing, but the fact of the matter,
I don't know if they did or not. That's what I'm trying to say. And to the ending,
Mr. Clements, I understand you believe you should be on the lease, and you may be right about that. But the fact of the matter was the apartment complex did not put you on the lease, correct?
I don't, that's what I'm trying to tell you. I don't know that for a fact it could have been something that they did on their own due to the fact of what she's doing. Because like I said, there is a lot of things leading up to the situation. To the fact of the matter is there was a lot of fraudulent activity, and there was a lot of things that were lies and retaliation that are based around this whole case that shows there's a conspiracy going on, which is a criminal act, a federal criminal act. So there will be charges and things set on that basis as well, and everybody who's involved will be implicated in that. The fact of the matter is I went through the whole process of everything to get the lease. I've been here from the very beginning, and then me and Brandy, we had a joint business account, and she took all the money. That was the problem of our situation. And then she came to try to get me removed, which I didn't have a problem of even leaving, because I have conversations that showed that I wanted to leave many of times. The only reason at that point in time that I did not leave because I was not able. When she left with all the money, she took all the money out of the accounts, and she took the vehicle that I helped her procure, which I had no vehicle because I did not drive. And that's the reason why we got that vehicle, for her to drive, have her ability to move around and to be able to me to move around. I transferred my college from Houston to Austin when I moved here. So that's the reason why we were in the process. And now when she's talking about the rent being paid, of course, I was not access to the portal, but we did not have rent, which is on record should be a contempt and a lie, because we did not pay rent all the way into February, because we had a 3 months free move-in rent. So there was no rent for 3 months until the time she even wanted to get the apartment. So there was no her paying nothing. Neither one of us paid anything because their free rent was for 3 months. We moved in October. All the way into February was the date that we were supposed to start paying, which we had the incident in February 1st, where money became missing, and she came with the police to try to get me moved away. But like I had told her and had told her on previous times, I wouldn't have had a problem with leaving because I didn't want to. We broke up in January. The only reason we stayed, I got all the text messages to prove this. We broke up in January. The only reason we stayed together was due to the business account that was almost a combination of 30-something thousand with 2 accounts. Now, when that money was taken and she left me here stranded, I had no choice but to stay. What I was supposed to do? How was I supposed to leave? She
Mr.
took
Clements,
the vehicle and she took.
Mr. Clements, let me ask you this question. You keep referring to a lawyer. Do you have a lawyer that represents you in some other case?
I have a lawyer who assists me on information. I am a lawyer who I have paralegal experience as well. So I am representing myself, but I do have consultation that I am using from other lawyers. So I have case numbers. I have everything. I've done all my proper research as well as they have as well. And I'm representing myself, which I'm choosing to do because I know how to do, and I know the law themselves, which I have case numbers to substantiate, but I wanted to be able to put all this on record before I bring up the cases that are similar to my case.
All right. What is it you're asking the court today to do?
Pretty much, it's on my motion. I want you to go on my motion to modify the fact of the matter that she terminated her lease, and then she has no occupancy. She has not had occupancy since February. I have had ongoing occupancy since February alone, and she has no rights to the property, period. Which case numbers I'm going to tell you who substantiate those facts under court of law.
Mr. Clements, if you could just answer a couple of questions before you go back to what you're wanting to say. You say she left in February, meaning Miss Brandy left in February, correct?
Yes.
And that you have lived on the property since February, correct?
Yes.
And when did the did anybody ask you to leave after February?
No, the courts gave me permission to stay. They told me other the fact of the matter of when we went to court, when we went to JP1.
Mr. Clements, I know you want to get this out, but here's the thing. There are about 50 courts in Travis County, or a bunch.
JP1.
Okay, thank you. And so JP1 told you to do what?
For me to, since I had the rights to the property, to stay at my property and her stay at her property, which she had moved to the other location, which was a house that well, I ain't gonna say we, because it was her property, but I was also, that was the business of realty that we had, that she was renting out to other people, which was her cousin. So I guess she moved over there with her cousin. I don't know, but that's the property that is listed, that is her, that she's staying at.
Okay. So you're asking the court today to do what? To make a judgment on my motion to modify, which this hearing is based off of that motion. I have submitted all of the proper documentations of proof of that. And then she also validated that with her admitting the fact that she has gotten off the lease. Mr. Clements, the hearing today is not on any motion you have. The hearing today is on whether or not who has the greater right of possession to the property. And that's what
That is not true. That is not a true fact. I was notified by Priscilla. This is a preliminary hearing based off of my motion to modify, which all documents have been submitted and e-filed. And now, if you want to say something opposite, you could do that and be liable as well, because I already know what the situation is. The fact of the matter is, she has no ground, zero ground. She has no lease in her name.
Mr. Clements.
No lease at all.
Mr. Clements.
And I have rights to the property due to the occupancy. She has none of those rights, period.
Mr. Clements, I'm going to do this one more time, and then this hearing's going to be over, and I'll make a decision. Let me be clear. What I told you is the truth. And the reason it's the truth is because I'm, as a judge, get to decide what we're hearing today. And that's what I'm telling you we're hearing today. If you have other things that need to be heard, we may or may not put them on the docket. But until we do, the hearing today is about who has the greater right of possession. And if you think that that's not what we're having, that's why I'm telling you that's the hearing we're having. There may be other hearings we need to have. There may be other hearings that are set. But on this date, this time, this place, that's the hearing we're having. End of story. Okay. Now, is there anything else you think you need to testify about whether or not you're supposed to be in the apartment or not?
Yes. Again, I was given rights by a JP1 judge at that point to be able to remain at the property based on the appeal. She was, and when she lost when I lost the case that JP put on appeal, that's when she went and did the order for a protective order, claiming something happened way last year. Now, due to that order, she was told to stay at her property, and I stay at this property and let's have no contact, because she placed the order where we could have any contact. And that's why I've been,
Mr. Clements,
I've been at the property. Yes, sir.
Let me explain something to you. When a case is appealed, certain funds have to be put into the registry of the court. There is a rule.
And that was done. There was the order set on that. And there was the
Mr. Clements.
Yes, sir.
Let me help you out here. If you hear my voice and I am talking, you need to stop talking. So let me help you out. If I'm talking, you're not talking. In fact, you'll notice no one else is talking when I'm talking. All right.
Yes, sir. I understand but
Mr. Clements, what I'm saying is that we will check to see if there's money in the registry of the court. The last I checked, I didn't see any, but you have to do it every month. And anytime you don't do it, failure to do that can get you, means you may lose the right that you have, or that you claim to have, to the apartment, because that money has to be paid every single month on a specific date. And failure to do so can be used to say that you are no longer entitled to stay there.
Which is agreed on. Now, can I make a statement? The only reason I was speaking is when I was speaking and you were interrupting me, so I was not interrupting you. I was making statements, so I would not interrupt you.
Mr.
I
Clements,
just want to make a, yes,
Mr.
sir.
Clements, you see how you stopped just then when I started talking? Let me be clear. If I start talking, I'm not interrupting anybody. Thank you. Now, proceed.
Okay. Well, the paperwork was submitted by JP1 due to the ability not to pay, due to the fact that she's taken all the money. So how was I able to pay anything when she had all the money? The courts agreed on the motion. We went to JP1. Even she contested the motion, and the judge overruled her contestant of the motion. So that paperwork was submitted for inability to pay. So there's no cause of putting anything to the registry when that was already accepted. There is no registry for that.
Mr. Clements, I'm going to tell you right now that that's incorrect.
Okay. May I speak, or are you still speaking, sir?
I'm not talking, so yes, you can.
Yes. Well, again, the paperwork was filled out to JP1 for the inability to pay.
Hold on. Did you fill out paperwork?
Yes, we did, and we had
I'm saying, did
hearing.
you? My question is not about Miss Brandy. My question is about you. Did you fill out paperwork?
Yes, I am the one who filled out the inability to pay. The inability to pay paperwork. Then she contested, saying that I did have the money to pay, and we went to a hearing at JP1 other than the eviction hearing, after the eviction hearing, which they agreed that I had the inability to pay. So that was put in to the docket, and I was granted the relief of not having to put money into the registry.
Okay.
All proper paperwork was filed, and the hearing was set with her contestant that was vetoed and rejected, and mine accepted at JP1.
I understand what you're saying. You believe that you were not required to put any money into the registry of the court for the entirety of the time that you've been living there after this once the appeal was done. Is that your belief?
There's no belief there was a hearing based on the fact of that. We voted in front of the JP1, and there was an order set by the judge herself. The paperwork was filed, the inability to pay, which you as a judge should know what that paperwork is. That
Yes.
paperwork is based off of the registry that you're supposed to pay. And she was contesting that I did have the money to pay. And we both went in front of the judge after the eviction hearing and for
I'm just
different.
trying to get what your belief is, because what I know and what you know are very different things.
Well, what I was advised on and what I was told is fact, and what was also rendered in the courts.
Okay.
The judge vetoed her contestant and agreed on the fact of the matter, and there was set that I was to remain at the property until the appeal, and there was no money to be paid for any basis of anything, because she did. First of all, she didn't even up under her suit. She never asked for any money, and secondly, there was the basis of the inability paperwork that the hearing was submitted and agreed on by the judge, and the hearing substantiated.
Anything else?
After that hearing was set, which I lost in the hearing, then there was the Brandy Milliken went and filed the court order for protective order, which is after the loss. And she claims stuff happened way in December and January, which is, how can you wait after a verdict than to go do something and claim. So now on the fact of the matter, I'm here under a protective order that is ungrounded and unsubstantiated.
Anything else?
I didn't do anything to her. So I wanted to be able to put the case numbers that I have on file, and I've already been looked up and searched. There's a case of C1C-CV-24-001987, appeal of eviction judgment, tenant claims retaliation. Then there's also a C-1-CV-23-03-00254 lease termination dispute appeal filed by tenant. And there's also many multiple ones, but there's another one I'm going to list on file. C-1-CV-24-001421 eviction appeal, tenant not allowed wrongful lockout. So when she speak of things happen in April, the lockout, there was already courts already told that I was able to stay at the property, and she stayed at her property. That proves that the apartment complex has went many laws. They have broken laws. They have refused my mail. I have not been able to get my mail, which is a federal offense, due to the fact that she has all the stuff to get. When she left, she took the keys to the mailbox. She also took the entry to me coming into the apartment. After she left, I went in our preferred vehicle, and my vehicle has been towed twice because they won't allow me to register my vehicle. They have made it very difficult for me to be in this environment when I have total rights to be here by the judge from JP1. Now,
Mr. Clements, all of
yes,
those,
sir.
all of those to me sound like things that you have against the apartment complex. I'm not here about that today.
I got that, sir. Yes, sir. That is set for that, but also I'm just making it known on the court that this is the basis of why her statements, because she was allowed to make that statement, and I am making a counter claim against those statements. That's false. So that's substantiating my claim. She was free. Yes, sir.
When we get to the part where we're dealing with that, we're not talking about any of that today. If you have causes of action that you have filed in the court and that their hearings need to be set on those causes of action, I'm sure the apartment complex can find a lawyer who will deal with you on those sorts of things. What I'm trying to do today is figure out who is supposed to have the greater right of power to have this apartment. And what is the apartment complex number? What is it, the number of the apartment complex you're staying in? Okay. And all right. Is there anything else?
Well, I have made the statements, and the case files to substantiate the appeals based off the fact that even her admittance, as well as the documents that were submitted for the motion to modify, that she terminated her lease, and she is no longer a resident here under lease as well as occupancy. So she has no rights to the property. I have, and I have been an ongoing occupant since February. So I have total rights of property based off of my ongoing presence, as well as the order from the JP1 court. And with her terminating her lease, she has no grounds at all to even be here in this meeting, which is off to the fact that the order that was set by the executive order set by the governor, this is a waste of taxpayer money. This is not an emergency. She should be fought against for the fact of even coming to this hearing or having this hearing even going about when she has no grounds. She has no lease and she has no occupancy. So what grounds does she even have to be in front of you and even accusing me of anything, and also making a statement of wanting me off the property? If there's anyone to have grounds to want me off property, it's not her. It's the apartment complex, which they should go through the process of getting me removed if that's the case, which they didn't. They made a deal with me to procure over the property, which I sent them the information of them with my name, which also gave the grounds of them giving me a lease in my name, with them putting payments in my name that are owed and sent to me, that is also some that's
Mr.
giving me the
Clements,
right to
Mr.
property.
Clements, they gave you a lease.
They gave me paper. Yes, I went and filed the lease as well as and they told me that you need to finish the court up before all of that. But then they also came back.
Mr. Clements, the record is going to reflect that you said the apartment complex, or worse to this effect, that the apartment complex gave you a lease. Do you have a copy of that?
No, I did not say that. I said that I did go and file for a lease with the apartment complex, and they said that I went through paperwork. They also sent me paperwork showing what I will owe, which I submitted that with my name and a signature by everyone involved. There was never a lease given to me due to the fact of the matter that the court was still basing going on off of what's going on. So they never gave me a lease. But the paperwork that I submitted of them giving me what I supposedly owe, all of the back pay with my name and signature of rent past due, would substantiate my claims to property, and they're aware and agreement of that. And that's when they gave me that was during the time period when they said that Brandy had removed herself from lease and that I was held liable for the payments after her removal.
Okay. Anything else?
That's it, sir.
All right. Thank you. Ms. Brandy, Ms. Milligan, do you have anything else?
Yes, sir. I do.
All right.
Can I speak now?
Yes, ma'am.
Okay. Yeah. So as far as this money that he's talking about, so let me be clear. This man is a liar. He's a manipulator, and he
Ma'am, I just
yes.
need to know what it is you want to talk about.
I
and
want
why
to
you
talk
don't
about
want to believe-
the money.
Yeah, go ahead.
Okay, so that money was gotten with my what do you call it? My social security number, my rapport as far as loans is concerned, as far as the card that he claims he helps me with. I've been with my credit union, sir, for 24 years. So this man did not help me get that vehicle. Again, my
I
report.
understand that, but I'm going to remind you of what I told him. This is about
Okay.
who
All
has
right.
the greater right of suppression,
Okay.
possession here.
Yes, sir.
So I want you to focus on that because there are some
Yes,
things
sir.
I think you want to say about that, and then we're done. Go ahead.
Okay. Yeah. So basically, that I guess that's pretty much it. I also forgot to mention to you that there is a letter also that I filed also in
You filed it where?
the same place I filed the other documents.
Okay, within that letter is also admitted.
Yes. So all of that. So I forgot to mention it. So the letter and all of the other stuff that I mentioned to you.
All right. All right. Thank you all very much. I'm going to take this case under advisement. I'll get back to you as soon as I can.
Thank you.
Sir, can I make one more statement, sir?
He gets the last word, but yes, you may.
Yes, sir. Since all of her stuff is submitted, I have sent
Hold on. Let me be clear what I'm submitting. I am submitting the documents that are in the file of the JP court and that were done at the JP court. So I've taken judicial notice of all documents and evidence that was submitted to the JP court, and I'm admitting those documents that were submitted at the JP court.
Can you admit the inability to pay as well, because that has also been submitted?
That's a part of the record, and if I've taken judicial notice of the record of the court, and if that's a part of the record of the court, that's what I'm going to submitted. What? I'm sorry, I couldn't hear you.
I'm sorry, sir. Can you put it on record? Can it be officially submitted as you put on record for all of her documents?
I believe it's already there as part of the record of the JP court.
Right. But I'm asking, can you put it on record that you officially submitted to your court?
I've already done that. I said I would take judicial notice of all the things that had to do with the court and all the evidence that had to do with the court. And part of that is the record of the court and whether the paperwork is there.
Well, I have paperwork also that I retained, so I have the paperwork so as well. So yes.
All right. All right. I'm going to take it under advisement. I will talk with you all at a different time. Thank you very much for your time.
This is filed as a demand for non-payment of rent. This is a new complex just on the edge of Centerville with 54 units in it. Is that correct?
Yes.
And the rents are about $1,000 a month. And I had expected once the place was up, we'd start to see cases from there. We haven't seen very many, but we're starting to see them. Also here, on the complaint, are Sarah Strout and Joseph Whitaker. Ms. Hively has a personal protection order against Joseph Whitaker, which is file number 25234PP, which prohibits Mr. Whitaker from coming to that address. And that order was issued by Judge Pattison in March. Well, the posture of the case is in right now, it's a demand for non-payment of rent, that the rent is delinquent. Mr. Bush has provided me with a accounting sheet, which I greatly appreciate. At this point through August, Mr. Bush, you contend the rent arrearage is $3,000.
Yes, Your Honor.
With a $213 in cost, 67 cents, and $120 in late fees through August. The amount is $3,333.67. Is that correct?
Yes, Your Honor.
All right. Ms. Hively, you sent me a letter and set forth the background here, and I'm aware of the circumstances. I also got some other correspondence and some emails, but this is simply a matter of whether the rent is paid or not. At this point, they contend that your rent through August is $3,000, which means it hasn't been paid in June, July, or August. What's your position?
I sent you a copy of the payment history.
Yes.
I do believe it was paid in June. I'm not 100% sure, but
well, you sent me this thing. It shows March, April, May. That doesn't show June.
okay. Well, here's the thing, Your Honor. I'm not opposed to non-payment. That's not where I had asked for a written early termination due to domestic violence because he would not leave the property and nobody was making him leave the property.
Well, it's not the landlord can make him leave the property with a legal action, but they can't just force him out. But theoretically, he was in violation of the PPO, and the sheriff should have been. So are you no longer there?
I left there in March, and then I asked in March, I sent you a screenshot of mine and her conversations where I asked for an early termination due to the events that were taking place and the abuse that was taking place. Because I could no longer stay there and nobody was forcing him out.
All right. Let's talk about this. So are you willing to just relinquish the unit? Do you have all your stuff out?
No, I ended up I went there one day with the police officers. They still wouldn't make him leave even with the PPO order. I don't know why. They didn't give me an explanation. I was able to grab one carload of things and we fled to another state because he was threatening to kill me. But this eviction is going to cause problems for my future because nobody's going to want to rent to me because of his abuse and his choices and his decision. And I didn't have anybody supporting me to get away from him.
All right, so you're out, you're not living there, but all your stuff is still there?
Yeah, I just pretty much washed my hands of the whole situation. I don't want nothing to do with him. He was still there up until I guess the police officers made him leave. Yeah, I just don't want anything to do with that man or my belongings. I can start over. That's fine.
Sir?
Is he there?
Yes, I'm here right now.
All right, well, you're late to your own party.
No, I've been trying to log in, but it wasn't working. Sir, she has charges.
Well, just a minute. Are you Joseph Whitaker?
I am, sir.
All right, I ask you to take your hat off.
Your Honor, I even have an email from Joseph Whitaker.
Stop. All right, Mr. Whitaker, are you still at this apartment? No, he's frozen. Mr. Whitaker,
Yes,
are you still living there at this address?
I am. Yes.
All right, well, you got to pay the rent. You owe $3,000 in rent, $213 in court costs, and $120 in late fees. So the total amount of rent due is $3,333.67.
I applied for the MDHHS, the SER, the SIR application. I'm just waiting to hear back.
All right. One of the problems is the personal protection order that's in effect prohibits you from being at 219 Venture Boulevard, Apartment 1. So you have a personal protection order in effect that says you're not supposed to live there.
It shouldn't be in effect anymore. I had went in and what is it
Still
called?
is, Your Honor.
No, it's not. No, it's not.
I called and made sure from the judge
Stop, Mr. Whitaker. The order is in effect. You don't just call up and ask them to drop it. Judge Pattison orders
I didn't call. I actually went there. I even tried to serve her. I tried to serve her papers to go to court for that, and she never showed up.
All right. The PPO is in effect. You're not supposed to be living there, but she's not there. So I guess maybe it's not as important. I can't imagine they're going to give you money to pay your rent on a place that you're not supposed to be living at. But the law requires I adjourn this for 7 days.
Okay.
And then I'm going to tell you that you owe $3,333.67 by 10 days from next Friday, which was, I'm sorry?
That was on her end. I don't know.
Yeah, Miss Hively, what did you want to say?
No, that wasn't me. I'm sorry.
Okay.
I was just
anyway, Miss Hively, you're out of there, so it's less crucial for you because you don't really care. If he doesn't pay the rent, he has to move out, and that's up to him. If
well,
we
I had
get
to leave. I didn't have a choice. He wouldn't leave. I even have an email from him saying, "Please don't kick me out." That's why he ended up putting his hands on me.
No, I never put her. I never.
Shut up. Stop. This isn't a PPO hearing. It's a non-payment of rent hearing.
Yeah.
And we're quite busy next Friday. 9, 20, 10, 10, 10, 10, 30, 11.
Embarrassing.
John, you're going to have several of these. How about if we continue this to 8:30 on Friday, August 15th? Does that work for you? Oh, that's the first. That's Judge Pattison's pretrial date.
Are you talking the 18th, Your Honor?
Yes, the 15th, Friday the 15th.
Okay, I have one already with you. I have one pretrial right now scheduled early that morning. I think I have something.
Which case do you have with me?
I don't know. I think it's set about
Memory
10:30.
Memory Lane at 10:30. Let's set this for 10:40.
That should work.
August 15th. All right, Miss Hively.
Yes, sir.
You're also welcome to be here. I'm going to tell him that the rent has to be paid or he's subject to being evicted. It's unlikely he's going to get emergency financial assistance for a house he's not supposed to be in. But we'll see where that goes. If the rent is paid, then you get to stay. If the rent is not paid, then he's going to have to move out by August 25th or be subject to being evicted. But we will revisit this entire matter next Friday at 10:40.
Your Honor, can we make any, where is Sarah Stout, the other defendant?
Yeah, where is Sarah Stout?
I'm here.
All right, who is she?
She's named in the complaint.
Yeah, how are you related to this, Miss Stout?
She was my roommate.
All right, so she's with Natasha.
Your Honor, also... a minute, can I say something as well?
Yes.
Sarah moved Joseph in. Joseph is never even on the lease. We rented to Tasha and Sarah.
I didn't move.
I moved in the same time they did.
No, he wasn't welcome there, Your Honor, and I have proof of it if you need it.
Stop lying, dude. You gave me the house key. You gave me the house key. Stop lying.
All right.
Your Honor, like I said, I have proof if you need it.
Oh, yes, and I do too. God.
Well, let's take a look at the lease. Well, anyway.
I actually moved in before they did, to be honest with you, a week before they did.
Well, you're not on the lease.
Well, I didn't know that.
You're not on the lease, and you're not supposed to be there pursuant to a personal protection order. They're not going to give you any financial assistance to live there. You're not on the lease. So
I went to court for that PP order. I don't know why it's saying it's
active. Go to court. It hasn't been dismissed.
It should have been.
Well, perhaps, but it has not been. He's not on the lease. So I don't know what the deal is, but somebody's got to pay the rent, and Natasha and Sarah are not going to pay it. So my advice to you, Mr. Whitaker, is you find another place to move to, because I'm going to give you 10 days from next Friday to move. They're not going to give you any emergency financial assistance for a property on which you're not on the lease. So, all right, we'll address this further next Friday. That took us
much. I have a question. This is Natasha. Yes? Is this eviction going to be on my record?
It will be unless we otherwise resolve it.
So, due to no fault of my own and nobody making him leave, it's going to be on my record.
Hey, take responsibility,
I'm going to mute him. Yes. Nobody put you in a relationship with him. I'm not sure what happened, and I don't know why.
No. I wasn't in a relationship with him. I'm trying to tell you. I have an email from him telling him not to kick him out, and I told him he was never welcome there in the first place. Sarah had a relationship with him. Her and I had an agreement. He was not supposed to be there. He was not welcome
there. On you guys, but yes, it will go on your record unless it's somehow otherwise resolved. So I'll see you next Friday at 10:40.
Your Honor, do I need to be here too?
Are you Sarah?
Yes, I am Sarah.
Oh, I didn't realize you. Yes, you're welcome to be there too, Sarah. So you were in the relationship with Joseph?
Yes.
All right, this is even more complicated than I thought. I thought she was. Yes, but as far as I can see, you don't want to come back there anyway. So yes, you should all come back. All right, thank you. I'll remove you as well. So Sarah was here. She was not properly named. I didn't know who she was. All right, we're off like a herd of turtles. Mr. Whitaker, I'm going to remove you also and send you into the great wide open.
Okay, so the first guy, I have no idea what he was talking about. The whole time I was like, what? He's just rambling. He's just rambling BS. That's all it was. There was nothing else. So I think they just want him to move. That's all they want. They want him gone. And I think that's what's going to happen. But they just want him gone. And the second one, kind of the same thing. They just want him to move. They want them out. Whoever has moved or whoever hasn't moved, I couldn't tell how many people were what. But they just want him to move. Both of them. Just move. Anyway, thank you guys so much for watching, and I'll see you another time.